Good morning and welcome to the Senate Committee on Commerce and Labor. Would the Secretary please call roll?
Senator Daly? Here. Senator Allison? Present. Senator Flores? Present. Senator Lang? Here. Senator Rogish? Here. Senator Scheibel? Here. Senator Steinbeck? Here. Chair Pazina.
Present. Thank you so much. We not only have a quorum, we have everyone present and accounted for. Welcome to the members of our audience in Carson City, in Las Vegas, as well as those that are joining us online. Before we begin, I'd like to make just a few housekeeping announcements. First, I'd like to remind everyone to please silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of testifying. And if you wish to testify in person, please sign in at the door and provide the committee secretary with your business card. When testifying in person, please turn on the microphones to speak and off to listen, as we'll have those listening in Las Vegas as well as online. And anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Also, committee members will be using their laptops to view handouts and other exhibits. Please do not view this as a sign of disrespect or inattention. All right, so in regards to the agenda today, we are going to get started with a motion to reconsider on Senate Bill 168, and then we're going to move into our hearings. I would also note that, and this is a very last-minute thing, Senate Bill 397 has been pulled from today's agenda. So please note again that 397 has been pulled from today's agenda. So we'll hear the bills in the order of first Senate Bill 317, then 429, then 438, then 440. Give me just okay, so members, we previously voted to recommend that Senate Bill 168, which revises provisions relating to cannabis, be amended and do pass as amended. However, bill stakeholders discovered there was an issue with the amendments that justifies reopening this matter for further deliberation. Specifically, the amendment should not have included item 3 on the work session document, which added to section 1, subsection 2DA, requirement for the Cannabis Compliance Board to adopt regulations setting forth circumstances for terminating a hold order for cannabis or cannabis product due to alleged use of a pesticide that is not permitted. It was not the intent to add this amendment, and I'm asking for your vote to reconsider our previous action to amend and do pass this bill. Once we reconsider our previous motion, the committee can consider the same amendments in the work session document that's located on all of your desks, except for item 3. And I'm now going to reopen the work session on Senate Bill 168. Members, you should have that copy of the work session document before you. And at this point, I will entertain a motion to reconsider our previous action that Senate Bill 168 be amended and passed as amended during our work session on March 21st.
Motion to reconsider Senate Bill 168.
Thank you so much. We have a motion from Senator Daly to reconsider, and we have a second from Senator Scheibel. Is there any discussion? Okay. Thank you so much. All in favor, please say aye.
Aye.
Any opposed? Thank you so much. The motion to reconsider carries, and our previous recommendation on Senate Bill 168 is now reopened as though it had not been decided. Next, we're going to reconsider Senate Bill 168 without item 3 as set forth in the work session document before you. Please see also the removed language of the corresponding conceptual amendment on page 3 of the work session document. Removing this amendment will preserve the language as originally drafted in the bill in this section. Okay, I know this is a lot this morning for 8 a.m. Members, are there any questions? Okay. I will entertain a motion on SB 168 to amend and do pass.
So moved.
Thank you so much. We have a motion to amend and do pass from Senator Scheibel, and we have a second from Senator Daly. Is there any further discussion? Okay. All in favor, please say aye. Aye. Any opposed? Okay, thank you so much. The motion carries on Senate Bill 168, and we will once again assign that floor statement to Senator Wynn. Thank you so much this morning. We are now going to move to the next item on our agenda, which is going to be a bill hearing on Senate Bill 317, which revises provisions relating to industrial insurance. And this is a bill by Senator Daly. However, we are going to have his partner with NJA come up and introduce this bill presentation. Thank you so much.
Thank you, Chair Scheibel. Jason Mills on behalf of the Nevada Justice Association. I'm sorry. Yes, I just did one with her the other day. I apologize, Chair Pizzina. Yeah, I was up a little late working on this. My apologies. I think John Noble and Terry Chambers are also going to come to the table and present with me as well, and I believe Dalton Hooks in Las Vegas as well. For the record, my name is Jason Mills, Jasonmills, Chair Pizzina, and I am on behalf of the Nevada Justice Association. The bill that you have in front of you today that's from LCB has been dramatically altered and updated after meeting with all of the shareholders that approached us from the major industry players, major insurers, self-insurers, and self-insured groups. Their issues and concerns were addressed and has resulted in the proposed amendment that has been circulated to your entire committee as well as given to your staff. That is the proposed amendment that we'll be working from and talking on today. Just to give you a brief background on why and how we got here, Chair, the Nevada workers' compensation system is over 100 years old, dating back to 1911. We're one of the first states in the nation to adopt a workers' compensation system. In fact, those rules were adopted after and in the wake of the Industrial Revolution, and what happened was effectively workers' compensation systems had to be created to deal with the change in our society. So instead of employees having to sue their employers and showing fault of their employers, and employers defending cases to show that their employees did some sort of fault, systems were created all across the country at the turn of the century. What it does is it allows for quick and efficient payment of benefits for those that are injured while working for employers. And fault need not be addressed. So we don't have to look at the fault of the employer or the fault of the employee. That system has grown in the nation and in the state and has been modified many times. In 1947, there were dramatic alterations in the state of Nevada to the workers' compensation system. Again in the 1970s. And most recently in the 1990s, the system was completely overhauled and updated. Why do I bring that up? Because this grand bargain, this deal between labor, the workers, and the employers and the insurers that insure them is constantly moving in a state of flux as our society continues to evolve and the way we work and interact with one another is always changing. I'm bringing that up because this will always be a process in motion. It will always be something that needs to be addressed by legislators such as yourself. And that is why we're here today, to address the very issues that are constantly needing attention and to be addressed here in Nevada. So turning to that, I'm going to turn to the language in the bill that we're seeking to amend. While I recognize that I think there's some 42 sections in this bill, and it is quite extensive and big, the good news for each and every one of you is 19 of those sections are dealing with a couple of issues, and much of that is being removed. So let me begin with pointing out that essentially sections 1, 2, and 4 through 13 dealt with originally where we were seeking to amend industrial providers, the people that give care, beyond just MDs and DOs and chiropractors, to include dentists and podiatrists and audiologists and therapists and all the other types of physicians that perform care, but there is no standardized list or system that controls how these work. We have removed all that for the key reason that the insurers and the employers have pointed out that the current system of our list is somewhat problematic. I think all of you have heard earlier bills this session already on what's the problem with the lists. So their suggestion was, why don't we fix the way we're dealing with the current lists of treaters, of providers, of doctors, and how they interact with the insurers and how they interact with claimants before we create an entire new body of additional providers that have the similar and same problems that the existing list have. We thought that was wise, so we removed all of that language. The other sections that they're essentially dealing with 7 different sections. That would be sections 18, 21, 22, 26, 31, and 34, have to do with one of the more recent changes in the statutory system in the 1990s was managed care organizations were thought to be going to be a large part of how workers' compensation transitioned from the old state-run system to the private system. It turns out to be that's not truly the case. What this system had was internal review or utilization review processes that you would have to first go to that private company's internal review system before you could go to the hearing and appeals officers. We found out in the last 30, 35 years that not only does that system not work and it slows the entire system down, it's not even really being utilized by any of the organizations. It's not really being utilized very much by the courts, and it is basically cumbersome and antiquated. The utilization review still exists for these companies, but if there are problems with it, the parties go where they go for all of the disputes. The hearing and appeals office, the hearing officers, the appeals officers to address it. So that's essentially those sections of the bill. So with that, 19 sections of what we're about to talk about are dealt with or disposed with quite quickly and efficiently. So I want to turn to your attention to the rest of the changes. First, the Section 3 indicates that we're going to be changing 616D 120 penalties. We originally were looking to add additional penalties. Senator Daley last session did dramatic changes and helped injured workers in this space. And frankly, the insurers and employers came to us and said, we haven't had time to let that change in the law really settled in before you should start adding additional things that we could become liable for. We thought that was reasonable since Senator Daley's bill from last session is just now starting to be understood and started to be followed up through the division. So we removed that section as well. With regard to the PTSD burdens in Section 17s, we've reinstalled the original language. Clear and convincing evidence we thought was tended to be an overextensive and somewhat harsh burden, but in reality, the insurers and employers have talked to us, and we tend to agree that it has not been a major or significant problem in bringing these cases, i.e. the burden of proof. So there would be no need to adjust that burden of proof from where it's at. Being a practitioner for the last 25 years, I would agree with that, so we removed that section as well. What we did do is add language that indicates that psychological evidence can now be used. What am I talking about? The statute currently indicates that you have to have medical or psychiatric evidence to bring a mental or stress claim under the statute. The problem is mental or psychiatric are effectively the same term. You need to be a medical doctor or a doctor of osteopathic medicine to be a psychiatrist. Therefore, any evidence that they're rendering is medical in nature. So in a way, the statute was duplicative. We're leaving that language in there, but now to add psychological evidence, meaning PhDs, therapists, licensed clinicians can obviously diagnose these conditions, and these are the people that do that in this day and age, and particularly treat in that space. With regard to Section 20, we're adding a statutory requirement that the Hearing and Appeals Division update and keeps a calendar online of all the hearing and appeals so that everyone in the community knows that when these hearing and appeals are happening and everyone can see, and openness is a good thing. I'd like to commend the Hearing and Appeals Division. They're already doing that, but they're just doing that because they think it's a good idea. We agree with them. So rather than if the administration in that division ever changes, we don't want that to go away. So we want what they're doing to continue. So we put language in there to essentially make what they're doing statutized. With regard to Section 23, addresses the change in statutizes stay motion procedures and rules for appeals. What we're talking about there is when a hearing or appeals officer has ruled or a district court has ruled, often the party who has lost seeks a motion for stay, and a court then has to use burdens that are set forth in our rules of civil procedure and in our case law. What we've done here is statutized those rules of civil procedure and the case law requirements that are already in our rule system, but not every single judge, for whatever reason, looks at those, so we're putting it in statute to make it clear on how those rules should be applied on stay motions. With regard to Section 24, there's a problem on petitions for judicial review, that is after the parties lose and go to the district court, and it typically affects pro per litigants. And that is if they use the wrong courtroom, didn't name the right party, didn't go to the right venue. Their cases are often dismissed on procedural grounds. procedural grounds and not on the merits. And that's from case law that's developed through the courts over the years. Both parties think that that's incredibly burdensome from the parties, and it sometimes even bites professional parties, but most often it hits these pro se litigants. So what this amendment does is it points out as long as your time frame is complied with under the rules, the existing time frame, the 30 days to appeal, if you didn't technically name the right party, or if you didn't technically file it in the correct district court venue, that is not a basis to dismiss the merits, but rather a basis to essentially allow the parties to amend that and continue. With regards to Section 25, it also deals with stay motion procedures. That's another section. It deals with the district courts, how they deal with it, identical to how the appeals officers deal with it. Section 27 alters and changes what we call the temporary partial disability. This happens when a person is injured on the job, they come back to work, but they're only working very limited amount of hours, and they're still entitled to benefits above and beyond what they're getting paid on their job because they're not meeting their compensation rate. This is already existing law. What this rule does is sets forth the time frame when those payments need to begin, like they do in temporary total disability. Time frames are set all throughout the statute, and through an oversight, there was no time frame set when temporary partial disability payments were set to begin. This statutizes that. Section 32 also changes languages for petition for judicial review to be ruled on the merits. Again, there's two sections in the statutes on how petitions for judicial review are dealt with. So we had to not only amend it inside the actual act itself, but also on the petition for judicial review portion of the act. So it's effectively the same language repeated a second time for addressing cases that are moving up to the Nevada Supreme Court. Section 33 changes the time frame, Section 33 deals with how to apply and will on any claim when it opens, whether it's pending or whether it's reopened, and this bill will apply to that. So the key piece of change that I wanted to focus on was Section 14, so I'm backtracking. What I wanted to do was, notwithstanding this bill is rather large, it isn't as big as it looks. So Section 14 is really one of the critical areas that we wanted to amend on behalf of claimants, and that is how we deal with the list, the providers list. So significant changes are happening there. First and foremost, there's the rules require that the division maintain a list in counties of more than 100,000 people for 19 different specialties. We've learned that neurology, psychology, and general practice are generally not overrepresented in Clark County or or Washoe County, the counties that are affected. So we're removing those provisions that they have to maintain 12 physicians of those categories back to the regular category of 8, the catch-all category. The bill also changes that if an insurer removes a physician or chiropractic physician from their list, they can only do it in compliance with statute. That is typically when a doctor either withdraws themselves from the workers' compensation system, they don't want to do the work anymore, they don't want to be under contract anymore, or they've broken the law. Effectively, misdemeanor, felony, lost their license, or the division made a finding that they can have erred in what they're doing in workers' compensation so bad that it warrants removal. As I understand, in the 7 years since the law has changed, 2 doctors have fallen under that category where they have done something wrong and have been removed. The insurer's concern was, as time grew on, the list would start to get bloated with physicians that no longer practice in this field, and the list would be overrepresented by doctors who are not actually practicing and accepting these claims. So what we did is put a provision in here that allows the insurers, at their request, to every 3 years to review their lists in toto to add or remove doctors as they see fit. However, at all times, they are going to warrant that the lists that they are providing and the numbers of physicians that they're listing as required by the statutes will in fact accept and treat those claimants for those listed body parts. What am I talking about? Typically, these lists will sometimes have doctors listed, 12 different doctors of a particular category that they'll treat. You reach out to them and they won't do it. This conflicts with the insurer's desire to have doctors on their list that will take care of these patients. This conflicts with me and my client's desire to have them taken care of for their injuries. So what we want to do is make sure that the insurer is now warranting that the doctors that they've put on their list will, in fact, accept and treat these patients. And if they don't, if the doctors are on that list and they don't meet the minimum numbers in the statute, well, then the claimant can choose any other doctor inside the state system that will accept and treat. This puts incentive on the insurers to be diligent in maintaining their list, and also gives them the ability every 3 years to review in toto their lists on whether or not the physicians that are on there are actually meeting with their contractual obligations, following the requirements that they're setting forth. It strikes a balance between the needs of the claimant and the needs of the insurer. It also provides that under subsection, I believe, 12, which Dalton Hooks will address later. That's under section 14, subsection 12 on page 12. Mr. Hooks will address later, which was an issue on how the panel physicians are maintained. And finally, the final section that I wanted to address that has a significant changes that are important and necessary is section 17. You'll find that on page 14 of the changes. What this does is it now allows for licensed psychologists, licensed clinical professional counselors, and licensed marriage and family therapists authorized to treat accepted mental stress injury claims. This does not expand or change mental stress injury claims themselves. That statute portion is unchanged. But what it does is it allows these licensed individuals to perform the treatment. Why is that necessary? Insurers and claimants have learned over the years that the psychiatrists that we have on the provider list are not enough. In Southern Nevada, there are only 2 that will accept and treat psychological psychiatric claims. And one of them is a new physician that was added, and he's already being overwhelmed and not accepting as many new cases as he did in the past. In Northern Nevada, there are none. This is a problem for insurers, providers, and most importantly, the people that are injured through mental and stress injuries. Most typically, police officers, firefighters, dispatchers, EMTs, the folks that protect all of us. They are not having the access to the mental health care on accepted claims. This rule adds the requirement that the insurer's panel list contain no fewer than 12 total of these combined types of practitioners to only treat and care for the conditions accepted on mental stress injury claims. And lastly, Section 35 adds a provision that allows physicians that are treating physicians on the providers list that also have in their direct employment, not subcontracted out, direct employment, to allow their physician assistants to do follow-up care on cases if the doctor has a direct employment relationship with the PA and the claimant consents. This was critical for us. We don't want the claimants being seen only by PAs and follow-up care. But the reality is, with the limited number of physicians in many of these areas, they are able to spread their ability to treat patients in follow-up care capacity if they have direct employment PAs. And again, only if the claimant agrees or accepts or allows to have that happen on his or her claim. And with that, I will turn over the section of the bills over to Mr. Noble to address the sections that he was working on. Thank you, Chair Pizzina.
Good morning. My name is John Noble with Employers Insurance. We are the largest domiciled workers' compensation carrier in Nevada. I'm going to start with our biggest change, which is the implementation of a closed formulary in Section 38 on page 61. So I'm sure everyone here has seen stories about the ever-increasing cost of prescription drugs. And it's no different in the workers' compensation system. Prescription drug payments comprise about 14% of every single workers' compensation claim. In response to this, about 17 states have implemented formularies as a useful cost containment mechanism. At its most basic level, this is just a list of drugs that an insurer agrees to cover. That said, it's not just an arbitrary limit on drug use. Effective formularies are designed to be broad enough to provide drug treatment options while also driving care to the most cost-effective and medically efficient results. In fact, Nevada already has a formulary for Medicaid, and then states like Texas and California implemented formularies for the workers' compensation system about 10 years ago. And my general policy rule is if those two can agree on anything, it has to be a halfway decent idea. So that's why this section is simply directing the Division of Industrial Relations to review and adopt an existing evidence-based formulary, such as the ACOM Practice Guidelines, or ODG formulary. These are developed by pharmacists and physicians along with the help of outside experts to create an easy-to-follow list of exclusions and inclusions for physicians and healthcare providers to follow. That said, it's not static. They're consistently updated as new drugs come out, medical literature comes out, and that sort of thing. It's also including important protections for injured workers, such as grandfathering in medications that they may already be on, emergency exemptions, and then also giving physicians and injured workers the ability to challenge for a drug that's medically necessary but may not be on the list. Outside of that, we have some tweaks to the audit structure in Nevada on Section 36 and 37 that reflect and clarify a bulletin that was issued last summer, and then also provide prior notice for in-person inspections. Outside of that, I'm just happy to take any questions when we wrap up, and I'll turn it over to our friends over at the Pro Group.
Good morning, Senator Pizzina and the committee. My name is Terry Chambers. I'm the Chief Operating Officer of Pro Group Management, and Pro Group administers 5 of Nevada's 7 self-insured groups. And I'll be going over sections 39 through 42, not unlike the other sections that have been presented. The sections that we're proposing right now are going to update and modernize the way that certain sections of statute have been treated. So looking at section 39, this section updates the policy year premium payroll cap. Nevada has a payroll cap of $36,000 per year per employee. Payroll is the basis of workers' comp premium. Basically, payroll times the rate equals premium. So no matter how much an employee makes during a calendar year, they could make $150,000. The payroll is capped at $36,000. The change will update this to bring it more in line with current compensation benefits. In other words, when calculating benefits for injured workers, we have to use their actual wages. However, on the premium side, you're limited with how much payroll you can use for the calculation of that premium. This also ties the payroll cap to annually adjusted average weekly wage for computing the maximum disability compensation for each fiscal year. This is certified by the Nevada Department of Employment, Training, and Rehabilitation. And this means that we won't have to come back to address this issue each legislative session. It would be tied to that index, and it would be changed automatically. Other benefits would include more predictable and evenly spread monthly premium payments over a policy year. Insurance rates to calculate the premium is anticipated to decrease and balance out because the premium is still covering the same number of employees. So while you may hear that my rates are going to go up, now you're going to charge my premium based on much more payroll, and that's going to mean it's going to cost more in my premium, my bottom line. But that's not the case, because if you look at 10 employees and they're making $36,000 a year, you're still covering 10 employees at 40 hours a week, no matter what, $36,000 a year, or if they were making $100,000 a year, the exposure is the same. So it's anticipated that the rates would then come down to accommodate the increase in the payroll. In other words, if you're an underwriter, you underwrite the risk. You have a certain amount of premium that you want to collect for the risk that you agree to cover. So there should not be any change in the rate or in the premium that's charged. The rate would be adjusted to accommodate for the increase in the payroll. Self-insured employers had expressed a concern that their excess insurance premiums would increase. We did reach out to Safety National Casualty Company, which is a large insurance provider of excess insurance, or what we call reinsurance, to get their thoughts. And the Senior Vice President of Underwriting provided the following statement. Should the Nevada payroll cap be adjusted or eliminated, our employee exposure would not change with any of the payroll cap adjustment. Thus, we would expect the rates to be decreased to maintain a similar premium should the cap be adjusted or eliminated. Again, it's a balancing act. The payroll goes up, the premium comes down so that you get to the amount of premium that you need to cover a risk. Moving on to Section 40, this clarifies a bonding requirement for third-party administrators of an association of self-insured employers. If you are a third-party administrator in Nevada, you have a bonding requirement. You're required to post a bond with the insurance commissioner, and that requirement is in Title 57 of the Insurance Code. There is an additional statute that says that if you are a third-party administrator administering claims for a self-insured group or association of self-insured employers, you have a bonding requirement. This section clarifies and eliminates the need for a duplicate bond. So in other words, if I'm a third-party administrator and I administer claims of a self-insured group, first and foremost, I'm going to post a bond with the insurance division for my business. The business is the same. The exposure is the same. I'm only handling the claims of a self-insured group. I should not be required to post a bond for the same amount of business in the insurance code and in 616B. So this clarifies that a section of NRS that requires a third-party administrator to post duplicate bonds, one required by the insurance statutes in Title 57 and one required by the industrial insurance statutes, Chapter 616B of NRS. With the change, a third-party administrator will no longer be required to post two bonds, which that's the case now, if they are administrating the claims of an association of self-insured employers. Section 41 adds a time frame for the state treasurer to disperse money from the subsequent injury account. This change requires the state treasurer to disperse money from the state's subsequent injury account once they receive a written order from the subsequent injury board. Currently, there's no time frame for disbursements, and payments are often delayed for months. This section places a sunset provision on the submission of qualified claims to request recovery from the subsequent injury accounts for associations of self-insured public or private employers. Newly filed subsequent injury claims that occur after September 30, 2025 will not qualify to be submitted for reimbursement to the subsequent injury account, and subsequent injury claims already approved for recovery would remain eligible for reimbursement from the account until these claims are closed. The account is funded by employer assessments and has no impact on claim benefit delivery and is administrative burden that is no longer serves the purpose that it was created for. Pardon me. Section 42 is a repeal of NRS 616B410. This is a very old statute. The statute was drafted in the 90s when self-insured groups were allowed to be formed out of the state industrial insurance system. At that time, it was meant to ensure that payroll audits were conducted utilizing SIC codes or standard industrial codes, as these codes were the basis of premium at that time for the state industrial insurance system. The statute is no longer relevant. SIS no longer exists. SIC codes no longer exist. And the need to have the insurance commissioner perform audits to verify the use of these SIC codes no longer exists. At that time, it was important because SIS had a concern that if a covered employer moved from the SIS system into a self-insured group, that the self-insured groups that were formed at that time might use the wrong classification code, might undercharge their premium. And so that original legislation was drafted to address that concern that SIS had, that should those members go out into a self-insured group, that they would not be charged the appropriate amount of premium and that they would not use the correct classification code. I'm happy to answer any questions that you might have. Thank you. Oh, and I'll hand this off to Dalton Hooks. Thank you.
Can you please advise him to turn his, sir, if you can turn your microphone on for
sorry,
us. Thank
got
you
it.
so much.
Yep. Sorry, folks. Good morning, Chair Pacina and members of the committee. My name is Dalton Hooks. That's Hooks. I am the founder of Hooks, Mang and Clement, which is the largest insurance workers' comp defense and administrative law firm in the state of Nevada. I am here on behalf of my client, the Nevada Self-Insurers Association, and its members. I want to start out by thanking Senator Daley, Mr. Mills, and the other stakeholders for their work on this bill with us. This has been the product of a considerable amount of compromise, and we're thankful to be working together on this. Just to kind of orient where I am starting, as Mr. Mills mentioned, in section 14, there's a bulk of the changes that are being made, and specifically, this deals with the doctor's list, and the portion that I've been asked to present addresses the administrator's role, and that being the administrator of the Division of Industrial Relations, the DIR, in this process. So we have had a couple of sessions where we've been working on these lists. This one deals with the publication of the doctor's lists so that injured workers and other stakeholders who need to know will be aware of what doctors are on the individual TPAs, insurers, or employers panels, and that those are published. This section, which is paragraph 12 of the amended language, addresses that by making clear that the administrator's role includes making sure that those panels of lists, which are to be in a searchable digital format so that information is useful to anyone who needs it, are uniform in terms of their layout. The DIR will have a role over that. The second part of it addresses that the administrator's role, however, in this regard, is effectively administerial. You are to take the lists that the TPA or employers have provided, that they have certified. Number one is correct, is consistent with the act. And number two, as Mr. Mills mentioned, as part of the modification, that those doctors that are listed therein will treat workers' compensation patients. To the extent that they don't, they can be removed, and that's all been covered earlier. But beyond receiving and publishing the list, the administrator's role does not include, beyond making sure that it's a searchable format, requiring anything beyond that in terms of, again, taking that list and publishing it effectively on their website. The next section that I've been asked to cover this morning is section 36, and this deals with administrative fines As Mr. Mills mentioned earlier, Senator Daley, through his work last session, made some substantial changes to this area. One that was not touched, however, is in the case of minor, what sometimes are termed de minimis, ministerial fines for things like using an outdated version of a form, C3 or C4. These are not things that affect claimant care. Or an example that one of the members gave me was they used a slash instead of a division sign. And that resulted in one of these ministerial fines, which can be $300, $375, small amounts. The problem that we had here is that there was, to the extent that you had multiple violations, a second or a third offense, those penalties would increase. However, there was no period in which they would reset. So if you became somebody who had 2 violations of using the wrong form over a course of time, you would be stuck at that enhanced fine into perpetuity. And there just isn't a corollary in any enforcement that I'm aware of. Certainly in OSHA, your citations drop off after a period of time. And that's all that we're doing here, is we're making that period 3 years, which aligns with the code provisions that already exist, and brings some clarity to that section. So same, I'd be happy to answer any questions. Those are the portions that I've been asked to present to you folks, and I will return the mic to Mr. Mills.
Jason Mills, Nevada Justice. Chair Pizzina, that concludes our presentation. Again, I would like to thank Senator Daley and your entire committee, as well as the major stakeholders that approached us, from gaming to insurers to employers to self-insured groups to self-insured associations. Every major association that approached us in discussing and working with this bill, we worked with and sat down with. I wanted to thank you for your time. We are open for questions for you or any of your members. Thank you very much.
Okay, thank you so much for the presentation on 317. Committee, do we have any questions? The silent group this morning. No questions from anyone. This was a lot to cover. Okay, I don't see any questions right now. That may change when it comes time for closing statements, but for now, we thank you and we'll have you step back from the table, and we will open it up for testimony in support of Senate Bill 317.
Good morning, Chair, members of the committee. My name is Mike Draper. I'm a partner at Argentum Partners, and I'm here today on behalf of the Nevada Franchised Auto Dealers Association, and we are very much in support of SB 317. I want to start by saying how much we appreciate Senator Daley's leadership on this, as well as Mr. Mills' efforts to work with us and so many others to create a bill that we think is a very good bill going forward. Particularly as a self-insured group, we very much support sections 37 through 40. Right now, Nevada might be the only state in the union that currently has a cap, so increasing that cap very much helps employers and other self-insured groups like ourselves. With that, I'll leave it brief, but there's very many. This is a very important bill for groups like ourselves, and we very much support it. So thank you.
Thank you, Chair Pizzina, committee members, Misty Grimmer, GRIMMER, representing the Nevada Resort Association. We too are appreciative of all of the conversations that have been had and the collaborative attitude of everybody to come together and bring these different ideas and pull them into one bill. And we appreciate Senator Daley for allowing his bill to be the work comp omnibus bill that we always have every session. And definitely appreciate the input of Mr. Mills and Mr. Hooks. After all these years in work comp, there's still a whole lot I don't understand, and those two gentlemen are very helpful in explaining it at my elementary level. So thank you very much, committee.
Good morning, Madam Chair, committee members. Todd Inglesby, representing the Professional Firefighters of Nevada and also SEIU. We want to thank the sponsor. I think this speaks volumes, just a collaboration of all the groups who worked on this. I will say that's probably a first since I've been coming up here for almost 10 years of all those groups working together. Mr. Mills obviously done a great job. Seeing Dalton Hooks on the same side is definitely a first. We want to thank everybody for this. We think it's what's best for not only workers, but for everybody. It's about getting our workers back to work where they want to be. It's about getting our union members back healthy and more productive when they do come back to work. So we thank everybody for this.
Good morning, Chair, members of the committee. My name is Troyce, Troyce. Last name Krumme, Krumme. We are here to testify in support of SB 317. We want to thank Senator Daley for sponsoring this bill, Jason Mills and the entire team of stakeholders that brought this together. Police officers are often injured in the line of duty, and when they have to start and to begin to navigate the insurance industry, it becomes a bit of a nightmare and confusion. Many times that creates a delay in getting them back to work, or those that just want to get back to serve their community are coming back injured just to get back on the job. And I don't think this panel, this committee would agree that either one of those are okay. This bill goes a long ways to dampen the confusion and to get our officers taken care of and back to work. Thank you.
Good morning, Madam Chair, committee members. Jason Lesher, Lesher, with the Washoe County Sheriff Deputies Association, also representing the Public Safety Alliance of Nevada, which represents the vast majority of peace officers in the state. I will just echo the sentiments of our colleagues here about the collaboration between the various groups here. For Senator Daley for carrying this bill, obviously he's helped us through some of these work comp issues in the past, and so once again, just getting our workers fixed up and back to work. And if they can't get back to work, let's get them moving on. So thank you.
Good morning, Madam Chair, members of the committee. My name is John Abel, John Abel, representing LVPPA and PSAN, and I'm going to say ditto. Thank you.
Thank you so much. Do we have anyone in Las Vegas who'd like to testify in support of Senate Bill 317? Okay, not seeing. Okay, go ahead.
Yes, Chair Pazina and members of the committee. My name is Charles Nort. I'm president of Nevada Alternative Solutions. I represent NAS, iGaming, and also TNR Painting Construction Group. And I want to commend as well Senator Daley and specifically Mr. Mills for his efforts and cooperation in listening to proposed language and changes and amendments and tweaking this particular thing. Initially, I was in opposition to the original bill as drafted. I had conversations with Senator Daley, and I appreciate Senator's time on that, especially Mr. Mills as well, because he came to me and said, I'm going to remove a lot of the heartache, wait for the amendment to come out. It did, and I was very pleased with that. And I'm pleased to tell the committee and Chair that this really resulted as a collaborative effort on everybody, specifically Mr. Hooks, who's sitting behind me. We've been in this business for some time. NAS has been a TPA for over 32 years, so I've seen many, many changes in the legislative sessions. That said, I want to just turn to two specific sections of the bill. Section 14. I commend the changes, and I concur entirely with the amendment as it is now, with providing at least a couple more months to get the list of providers in. And that's going to give time to finalize a lot of things. I think that's going to resolve in a lot less confusion, et cetera, on that. And then just turning specifically to 36. 36, I'm very pleased to see that administrative fine relief, not benefit penalties, but administrative fine release is also going to have a sunset now of 3 years, in essence, before it resets. Initially, during routine audits, it's been recently come to bear that the auditors are finding a violation, simple, ministerial, even clerical, and that they'll result in a fine. But however, they're looking back years to impose a more major fine without having a sunset. And by that, I mean, initially they could go back to day one, in my case, 32 years. And so I'm very pleased to see that there is actually a time frame or a sunset clause that if you haven't had a violation within the 3-year period and a subsequent audit takes place, it resets. And I'm very pleased to see the fine imposition or implementation from a minimal fine or notice of correction, by the way, which is sometimes much the case on merely administrative errors that do not impact the claimant or the financial aspects of a claim. And that I agree with totally. That said, I'm pleased to say that I am now fully in support of SB 317. And once again, Mr. Mills, thank you. I mean, he returns calls almost immediately. And the type of language and stuff and his responses are very intuitive and also lead to these types of proposals, because I actually proposed very specific language, as 36 has, for a sunset clause on administrative fines. Thank you again for your time, committee and chair.
Thank you so much. Okay, we are going to move to the phones. Broadcast, is there anyone on the phones who'd like to testify in support of Senate Bill 317?
If you would like to testify in support of Senate Bill 317, please press star 9 now to take your place in the queue or raise hand in your Zoom window. Computer user Jamie Chacon, it looks like you were unmuted. Please continue.
Okay,
Yes.
can you hear me? Can you hear me?
Yes, we can.
Okay, I am here to provide neutral testimony. My name is Jamie Lee Saishon, MD.
We're actually on testimony in support right now, but we would love to hear you when we get to testimony in neutral. But right now we're taking testimony in support on Senate Bill 317, and when we get to neutral, we will look forward to hearing from you.
Okay, sounds great.
Caller, please continue.
Hi, can you hear me?
Yes, we can.
Hi, my name is Austin Richardson. I'm a member with LVDSA. A BDR was submitted by the Interim Committee on Commerce and Labor. This BDR was for a bill that would have capped rent increases at 3% per year.
Sir, we're
We spent the
actually
last few
testifying in
months
support
collecting
right now on Senate Bill 317 regarding workers' comp, but it sounds like you have a very important thing to
And-
share during our public testimony at the end, and we would love to hear you during public comment. But is this in regards to the workers' comp Bill 317 testifying in support that we just heard?
I can hold.
Okay, thank you so much. We look forward to hearing you at the end in public comment. But right now, is there anyone else broadcast on the line who'd like to testify in support on Senate Bill 317?
Chair, you have no more callers wishing to testify in support at this time.
Thank you so much. And that will move us to testimony in opposition on Senate Bill 317. If there's anyone in our physical locations, please come to the table. And then after that, we will move back to the phone lines.
Thank you, Madam Chair. Alexis Motorex with the Nevada Chapter Associated General Contractors. We've got some concerns with the impact in Section 39 that tripling the payroll cap will have on employers, in particular construction employers. We feel that there needs to be a 4 to 5 year window prior to implementation to stabilize rates to ensure contractors have time to prepare for the potential increase in rates and liability. Thank you.
Good morning, Chair Pazina, members of the committee. For the record, my name is Jimmy Lau with Ferrari Reader Public Affairs, representing the Nevada Contractors Association. To save time, I will ditto our colleagues from the north of AGC. NCA is reviewing that provision of the bill as well for its potential impacts. Thank you.
Okay, thank you both so much. I don't see anyone approaching the table in Las Vegas in opposition of Senate Bill 317, and broadcast will go back to you. And this is for anyone who's in opposition only on Senate Bill 317 regarding workers' comp, which we just discussed. Thank you.
If you would like to testify in opposition of Senate Bill 317, please press star 9 now or raise hand in your Zoom window. Chair, you have no callers in opposition at this time.
Thank you. I did notice that there are now 2 people seated at the table in Las Vegas. Were you, if you're here to testify in opposition, you may proceed. If you're waiting for neutral, hold off. Okay, I'm seeing nodding heads, so I'm guessing that's neutral. Okay, thank you so much. All right, we are going to move to neutral now on Senate Bill 317. And you know what? We're going to start in Las Vegas since they were ready for me.
Thank you, Madam Chair, members of the committee. Victoria Carrion for the record. I am the administrator of the Division of Industrial Relations. We appreciate the discussions we've had with the sponsors about this legislation. We do have a few items for information for consideration of the committee and look forward to speaking to the sponsors more about these. In section 14 regarding the insurer provider lists, the amendment states that the administrator shall not require that insurer provider lists be submitted through any specific proprietary software platform or electronic system. So in October 2024, the Legislative Commission did adopt a regulation that actually did require that these lists be submitted electronically to us. And that system is, we put resources and money into it. That is set to go live on June 2nd, 2025. So we would appreciate additional conversation on that. The new system will make it easy for insurers to upload their lists. They'll just be able to do a simple CSV file, and it will make it really easy for injured workers to be able to search across different insurers, search for different specialties, different body parts that they're interested in. So we think that system will be of a great benefit. In addition, Section 17 does create a new insurer list of licensed medical health providers that we could also incorporate into this system. I think that would be something that would be worth discussing further in terms of a benefit to injured workers to be able to search for those. Section 36 creates a new graduated fine schedule for insurers and TPAs, and as you heard earlier, resets the timeline or resets the clock every 3 years. Did want to point out that audits are done on an every 5-year basis. So if it's only on every 3 years, then there's basically a blank slate in time for the audit. So that's something that may warrant further discussion. Also, in Section 37, there is a 3-day notice requirement for site visits from the administrator to check for compliance. Right now, there's no such notice requirement, and we have been doing some site visits and finding some non-compliance issues that we are addressing currently. I do want to say that I think it's kind of atypical that you would have a notice requirement for a regulatory agency. For example, in our OSHA statutes, which is also part of our agency, there is specifically a prohibition against providing any notice to the employer in advance of any visits. So with that, we're happy to answer any questions. I also have Jody McCollins here, who is our chief of our workers' compensation section, if there's any questions. Thank you, Madam Chair.
Okay, thank you so much. We are going to move to move to Carson City for testimony in neutral for Senate Bill 317.
Thank you, Madam Chair, members of the committee. Adam Plain, P-L-A-I-N, with the Nevada Division of Insurance. I apologize for not having written testimony. I'm just seeing the amendment. I will follow up with written comments for your convenience. 2 items that I will take in reverse ordinality real quick here. Section 42 of the amendment proposes to repeal 616B.410. The division doesn't have any issue with the repeal of that particular section because the commissioner can require an association to file a payroll audit pursuant to 616B.404 sub 4 paragraph A. But we do want to perhaps request consideration that statute 404 perhaps be considered for an amendment that requires the payroll audit to be completed in a timely fashion. I think we've had some conversations with parties that say, well, you can request the audit, but you can't require us to finish the audit. So that might be something to consider. And then as it relates to what's considered Section 39 of the amendment, which is the payroll cap that has been discussed some, we would perhaps note that Section 35 of the original bill is the effective date clause, and it causes the entire bill to be effective upon passage and approval. Now, wage rates and the payroll cap for fully insured companies and self-insured groups typically run through what's known as a rate service organization. In this case, Nevada uses NCCI, the National Council on Compensation Insurance, to set those wage multipliers. NCCI typically only updates their multipliers once a year, and it typically happens in the first quarter of any given calendar year. So we might request that at least Section 39 be given a different effective date as opposed to passage and approval, or else we will potentially see the payroll wage cap go up, but those multipliers not be adjusted for a period of 9 to 12 months afterwards. I think that's where the potential for a big disconnect in the payroll cap versus the rates charged to insurers that use those RSO multipliers will come in. So perhaps setting that particular section's effective date to first quarter of 2026 or July 1, 2026, something along those lines would give it a chance to even out. Thank you.
Good morning, Madam Chair, members of the committee. Paul Maratkin with the Vegas Chamber. The Chamber is neutral on SB 317. We appreciate the work that's been done on the compromise and support of those efforts. We're just doing a final review, but we anticipate with that final review we would move to support. But at this time, that we're neutral with this time to finalize this document. But again, appreciate the efforts done with the stakeholders to get to the compromise today. Thank you very much.
Thank you so much. And before we move to the phones in neutral, I would just say, we always enjoy having Adam Plain in the room for this. And Mr. Mills, I hope you have a chance to connect with him. And we appreciate all the work you've done with stakeholders on this. And with that, I believe we do have someone on the phones broadcast. Can you please have anyone who'd like to testify in neutral on Senate Bill 317 join us?
If you would like to testify neutral on Senate Bill 317, please press raise hand now in your Zoom window or *9 on your phone. Jamie, you are unmuted. You may continue.
All right, so I got the right time. Thank you so much. This is my first time doing this. My name is Jamie Lee Seichon, MD, and I also sent a written statement for your consideration. I am board certified in psychiatry, brain injury medicine, and neurology. I am neutral about the bill SB 317. However, I do have some concerns about clarification as well as differentiation of multiple providers. To refer to all such providers as licensed mental health providers as equals, with the standards they provide being different, contradicts the definitions of practice as set forth by the AMA guides and may add confusion to the stress claim section with respect to treatment. This also falls below the standard of care for current community practice. The DSM-5, which is the standard for diagnosis and is the product of the American Psychiatric Association, is utilized by multiple providers, yes, but other providers may lack the qualifications to make the appropriate industrial diagnosis and treatment decisions without supervision of a licensed psychiatrist who is board certified. In a community setting, the psychiatrist is always ultimately responsible for treatment planning as well as diagnosis. While other providers may be involved in treatment, it is with supervision and delegation by a psychiatrist who is a physician. To qualify all licensed providers and the evidence they provide as equivalent erodes the integrity of the medical profession and risks harm to patients with exposure to unqualified providers, incorrect diagnoses, and problematic treatment plans not in accordance with guidelines that may result in delays and denials of care. In other branches of medicine, there is a hierarchy with the physicians above other providers. A physician is required to certify guardianship needs or perform a DOT physical. But yet, to characterize all providers of mental health as the same proposes a lower standard for psychiatric conditions that would serve to undermine mental health care in general. To say that all providers are equal, despite different training requirements, as well as ongoing different training maintenance of certification requirements, just because they are licensed would be below the standard of care that is common practice in the community setting. This would effectively create an imbalanced lower standard for the workers' compensation system. It will result in delays in care due to bottom-up referrals when such unqualified providers fail to meet goals due to substandard care. Furthermore, it may discourage physicians from treating workers' compensation patients as requirements include additional training that may not be required by these other licensed professional boards. As a result, this may result in reduction of physicians and discouragement of future providers from obtaining additional training that is required for treating workers' compensation patients. It may also stigmatize stress claims. If the standard of mental health treatment under workers' compensation becomes quote unquote, any provider available, then the quality of such care will suffer for these above reasons, and the integrity of the system may be compromised. The greatest tool any provider has is therapeutic alliance, which also requires public trust in qualifications and standards. Therefore, I do suggest clarification of other providers and possible inclusion of supervision by a treating physician. Thank you.
Thank you so much, and thank you. We always appreciate when members of the public call in, so thank you so much for getting engaged in the legislative process, and we were really happy to welcome you here today. Broadcast, do we have anyone else who'd like to testify in neutral on the phone lines on 317?
You have no more callers wishing to testify neutral at this time.
Okay, thank you so much. Mr. Mills, do you have any closing statements?
Jason Mills, Nevada Justice Association. No, Chair Pazina. If any questions, happy to answer them.
I believe we do have a comment from our vice chair and bill sponsor.
And just a comment, thank you, Madam Chair. So I do want to thank everybody for the collaboration and the work and all the stuff. And everybody was giving me a lot of credit for that. I stayed out of it. So I was in the background, though, under glass with a sign that said break only in case of emergencies, right? And so apparently that was enough to make them all say, no, we don't want to get him involved, right? So just remember, as you go forward, I'll still be under glass, break in case of emergency. Thank you.
We will keep that in mind, Vice Chair. Do we have any other questions? Okay, thank you so much. And with that, we will close the bill hearing on Senate Bill 317. And thank you so much, Mr. Mills, and your co-presenters, both in Carson City and Las Vegas. A reminder to those that just joined us maybe a little bit later into the meeting that Senate Bill 397 has been pulled from the agenda per the sponsor. So we are going to move to the next item on our agenda, which is Senate Bill 429, revising provisions relating to social work. And I believe we get to welcome two of our senators, Senators Doñate and Titus. Welcome, along with co-presenters.
Good morning, Chair Pazian and committee members. I am Senator Robin Titus, representing Senate District 17, and I proudly say Senate District 17 is 6 rural counties: Douglas, Lyon, Churchill, Mineral, Esmeralda, and part of Nye. So I'm sitting here at the table with Senator Donate in his capacity as chair of the Joint Interim Standing Committee on HHS, and Dr. Eugenia Weiss, Associate Dean of the School of Social Work at the University School of Nevada, Reno. And I just want to note that it is an honor to sit with Senator Chair Donate, and it's just a perfect example of how healthcare issues in the state really cross both lines and really don't have a line, and that we work as bipartisan to get the problem solved as much as we can. SB 429, which provides social work students with compensation during the field practicums when serving in rural or underserved served areas of this state. So SB 429 is one of those solutions to getting access to health care in a rural and all of Nevada. Please note, as has happened frequently when bills are presented, despite all the work we can do to get them right the first time, once they actually are written and come out, we frequently say, oh, that's not what our intent was. And so please refer, and hopefully everybody has a conceptual amendment that we are working on. And it's significantly changed it. It's uploaded on Nellis. You should have copies of it, and that's what we will be addressing today. During the previous interim, I was a member of the Joint Interim Standing Committee on HHS. A major focus during that committee's meetings were issues related to the Nevada healthcare workforce, including the social worker pipeline. At its final meeting and work session in August last year, the committee unanimously voted to approve a draft of a bill based on a proposal that I had suggested to establish a social work apprentice program, which is how this bill began. As you already know, Nevada has experienced a critical shortage of healthcare professionals at all levels. We've heard so many bills. This committee, healthcare committee, across all spectrums, we have shortages. On top of that, the healthcare workforce is geographically maldistributed throughout the state, as all of us are, with significant workforce gaps in rural and frontier access in Nevada. Several factors influence whether providers choose to practice in Nevada, including the availability of education, practical training, and occupational licensing and other regulatory practices, among others. I want to briefly provide an overview about these crucial providers. Social workers are dedicated professionals who help individuals, families, and communities navigate life's challenges and improve their overall well-being. They provide support services such as counseling, connecting people with resources, advocating for those in need, and developing programs that address social issues. Social workers are critical for healthcare delivery, hospital functioning, mental health centers, community organizations, schools, and other social service agencies. And some of you might say, what is that fiscal conservative sitting there talking about social programs for? But we all know that investments in your social aspect of life makes an overall healthy community and healthy individuals, which in the long run are better for society and actually ends up costing society less overall. According to the Nevada Public Health Foundation, there are approximately 3.2 million people in Nevada served by only 2,700 licensed professional social workers, translating to just one social worker for every 1,200 citizens. This shortage is particularly severe in rural and frontier counties, and they have like a 0 to 5 social workers available to serve entire communities. According to testimony from the foundation last interim, many social work students are non-traditional, meaning they work full-time and go to school, but we need to help support these students throughout their educational programs. Further, the foundation noted Nevada social work students struggle to balance unpaid practicums of about 15 hours per week with classes and coursework, making full-time employment very difficult to help with their living expenses. That is what originally brought us this bill. We wanted to establish a program for social work students to address the shortage of social workers in our state and replicate the success of the Nurse Apprentice program. For those of you who do not know about this program, it helps nursing students to work under supervision, apprentices at approved healthcare facilities. The program has been a tremendous success with over 1,600 nursing students currently employed by the program and over 330 who were hired by a facility after graduation and licensure. So we were trying to look at what worked in our state, and that was one of the programs that had. However, after the HHS interim committee requested this bill, I learned that the social workers are regularly different than nurses. For instance, the Board of Social Workers does not have jurisdiction over social work students. Instead, the field practicums are part of the educational programs of the schools of social work, which we have in the state, both the University of Nevada, Las Vegas, and the University of Nevada, Reno. At this point, I'm going to hand it over to Dr. Weiss, who can speak more details to field the practicum requirements for those students, unless Senator Donate wanted that. All right, with that.
Thank you, Senator. I also want to say thank you, Madam Chair and committee members, for your attention today. So you may or may not know this, but social workers provide 60% of mental health care in the nation. And we are very, very underrepresented here in the state of Nevada as far as the provision of mental health services, as you all know. And as Senator Titus was mentioning, most of our students are non-traditional students, which means that they are often employed, they're working parents, they're not necessarily young folks coming out of school, out of high school and going right into college. So that is what we mean by non-traditional students. And some of them are second careers, where they're coming in, where they've already had a career, and now their passion is to help others. And so they seek degrees either at the bachelor's level, bachelor's of social work, or master's of social work. One of the biggest constraints that we have is that part of their education, both at the bachelor's and master's level, is that they have to complete practicum hours or field placements while they're in school. This is part of their education, and this is part of what is required from our accrediting body, the Council of Social Work Education. So we have 2 accredited schools of social work here in the state of Nevada, one through UNLV and the other through the University of Nevada, Reno, which I'm representing here today. But I'm really representing all social workers and social work students here. And so what happens is that we have students that come into our programs and they say, well, I can't do the practicum because that would mean I'd have to leave my full-time job. And I am the primary breadwinner, or, you know, we have a household with two breadwinners and there's no way that we can survive if I have to cut back on my job to part-time, or, you know, be able to do this practicum, which is 15 to 16 hours a week, total of 225 hours a semester. So at the bachelor's level, it's the completion would be for the practicum requirement is 450 hours. At the master's level, it's 900 hours. This is a ton of hours that they're doing basically free labor, which is really impossible for these folks that have a passion to become professional social workers. And so, so this is the dilemma that we face, is that we invite students to come into our programs, and then we say to them, you have to complete all of these hours for free, because most of the placements that we have in community agencies, healthcare facilities, hospitals, schools are not paid. They have no stipends. There's very few, such as the VA, that offers a stipend, but most of them, the majority of our placements, and we have about 600 agencies that we work with, are unpaid, which is a huge burden. So that means that folks either have to quit their jobs, their full-time jobs, or go to part-time, or they have to assume a great amount of debt through financial aid in order to become social workers. And then when they get out of their bachelor's or their master's, they have accumulated a huge amount of debt, and they're typically very low paid. So they'll be spending the rest of their lives paying off their loans. And so this is why this is so important, because we need the workforce. You all know this very well. Particularly in our rural frontier areas, in our underserved areas, there's barely any social workers there. And social workers touch every aspect of life. We have social workers in every domain that you can think of, in hospitals, in prisons, in schools. They round out in terms of every sort of well-being and mental health care that is provided. And so this is something that would make a huge difference, because then we could recruit more students into the profession, because they would know that their practicums would be paid, and therefore they can afford to feed their families and continue their education. And therefore, we can have more social workers for the state. If you have any questions, I'm happy to address.
Thank you. And with your permission, Chair, I'll go ahead and summarize a conceptual amendment to SB 429. As I stated earlier, the bill was originally modeled after the Nurse Apprentice Program, but it does not work for social worker students. Therefore, we met with several stakeholders prior to session, and I will tell you, more than several. It was a room full of folks across the spectrum of social work, with the chair present, Chair Donate, the social worker board, the universities, private social workers, just to get a concept about what this really would look like and how best could we help. And we came up with a plan to assist social worker programs to complete their field in a practicum. The amendment would remove the current provisions of the bill, instead provide the appropriation in Section 17 to both UNLV and UNR. Since enrollment at UNR is around 800 students and about 200 students in UNLV, the appropriation would be split 80-20 based on the student population. Both schools must use the additional funding to provide the scholarships to social work students enrolled in either bachelor's or master's program and complete their field practicums over 2 semesters. The amendment requires that the scholarship be provided to such students who complete their field practicum at practicum sites that, 1, are in a critical access hospital, a rural clinic hospital, or an emergency hospital, or in a census tract with low-income housing as designated by the United States Secretary of Housing and Urban Development, in a community which at least 20% of the households were not proficient in English, on tribal lands, tribal health centers, or government agencies primarily providing services for tribal members, in a county whose population is less than 100,000, which includes all rural and frontier communities. I would say that we wanted to make sure that the need for these healthcare providers is not just in the rural or frontier areas, but it's across the spectrum in urban areas, which we need healthcare in and social work in also. So with that, if Senator Donate has any questions, if not, we'll open it up to questions from the committee.
Okay, we'll start with Senator Scheibel. Thank you very much for the presentation.
Yes, thank you. I think this is a fantastic idea. I can certainly relate to students trying to get through, their graduate work and trying to get that experience. And if you're not getting paid for it, then it puts students in a very difficult position. So I love this idea. My question is about a breakdown of the funding, and I did understand what you were saying about the 800 students enrolled in UNR and approximately 200 in UNLV. And I wasn't entirely clear on if this was like a one-shot appropriation or if the idea was to continue this funding into the future and whether that 80-20 would remain or whether it's going to be tied to the per capita enrollment.
So,
thank you so much, Fabian Iñate, for the record. So to answer your question, Senator Scheibel, so I believe the intention was specifically to look at the breakdown of what we have right now. And so you are correct that it's my understanding of the bill that it's going to have to come for a renewal because eventually the money is going to run out, right? So we're going to need to come back for another appropriation. But certainly we can switch the language to say based on the enrollment so that if we want to say come back in 2027 and ask for a renewal of the funds, at least it's tied to the enrollment. So for an example, if UNLV increases their enrollment because they have more students taking advantage of the practicum, then maybe that we can just switch it based on an enrollment per capita basis, if that's what your recommendation is.
and if I might follow up on that, Senator Titus, for the record. So the ask is $2 million. And again, we had to start somewhere and figure out what's that breakdown look like, because we wanted to make sure we included the potential for all the social work students. And so that's the current breakdown. So to concur with the good senator to my left, I think we would like other schools to open up social work programs. So again, having that flexibility in 2 years when we come back, hopefully it's funded now, and we ask for different funding, maybe a different funding formula. There may be new schools, maybe new students, and that's a wonderful thing about a program like this. Thank you.
Yes, and hopefully we fund it $2 million this year, and then in 2027, everybody gets what they got this year, plus any new schools that open up or any new enrollments in UNLV, the appropriation goes up to 2.5 or 3 million. So I don't know if I have a suggestion about changing. I was just kind of looking more like legislative intent, I guess, was more what I was interested in. So thank you.
If I may follow up, this is Eugenia Weiss for the record, WEISS. Sorry, I didn't spell it out earlier. UNR is currently working on developing an online bachelor's of social work, and we're anticipating great growth because that's exactly who we're targeting. We're targeting folks out in the rural and frontier areas who want to become social workers. So we're starting an online program. So we're anticipating enrollment growth. And especially if we can offer this incentive for our students to be able to have paid practicums. Thank you.
Thank you so much. Senator Ellison.
Thank you, Madam Chair. And I know that there's a major need for this out there in the whole state. But one of the questions I got when I looked at this, the UNR and some of them, they have a lot of community colleges in there. Would the community colleges fall into this program? Do you know?
Well, currently, the programs are limited to where the social work programs are, and currently the only schools that offer this social work program, because it's a bachelor's level and then a master's level, are UNR and UNLV. If any of the other schools, we have other four-year universities in the state, if they were to offer the program, they certainly could. But again, it's all about where these programs are currently located.
Thank you, ma'am. And I'd like to see more of these programs expand. I mean, it's a big need for it. But a lot of the people that I've talked to that go to these programs, the biggest thing they're telling us is the pay for some of these social workers is so bad that they finally start looking for another trade to go to. But that's what I hear more than anything is they're just so underpaid and they can't keep them. But, so I don't know if you want to comment on that or not, but thank you. Thank you for the bill.
Just to, Senator Titus, for the record, just to address Senator Ellison's comment, I will say that one of the reasons for a bill like this is because of the salaries are so limited, students don't want to go into the debt for that career. If we can help offset some of their debt during the training, we may be able to encourage them to go out into these fields.
Thank you so much again for the presentation. I don't see any other questions from the committee. We really appreciate this, and obviously the need for social workers is immense. So thank you very much. And with that, we will open it up for testimony in support of Senate Bill 429, and we welcome anyone to come to the tables in our physical locations. And then after that, we will move to the phone lines for Senate Bill 429.
Thank you, Chair and members of the committee. Blaine Osborne, Nevada Rural Hospital Partners, here for the record. Thrilled to be here to be able to support Senate Bill 429. Senator Lang heard me testify in Senate Health last night. Healthcare workforce is the most serious challenge that our critical access hospitals and probably most hospitals in the state are currently facing. So this is a wonderful bill. Nevada Rural Hospital Partners is actually the subgrantee for the nursing apprenticeship program. So if you have any questions about the nurse apprenticeship program, I would be more than happy to address those for you. As Senator Titus said, it has been wildly successful, and it was done in response to the great nursing shortage in the state, particularly during the pandemic. We have a very similar shortage, as you've heard, for social workers. I know of one of my member critical access hospitals that has had an open social work position posted for more than 2 years now and is unable to find and hire a qualified social worker. So really appreciate the Interim Health Committee bringing this bill, and we are thrilled to be here in support. Thank you.
Chair Pazina, members of the Committee on Commerce and Labor, for the record, Leonardo Benavides with UNLV Day. We are here today in support of SB 429. I want to echo a lot of the sentiments of what Dr. Weiss from UNR said in regards to the work that we're doing at UNLV as well. Obviously, workforce, the healthcare workforce is very important for us as well. We believe that SB 429 gives us another tool in our toolbox to not only support our students, but in turn support the underserved areas where the social work can have the most impact. I did just want to note that right now we are at approximately 400 students enrolled in our social work program. And I also want to note that UNLV also helps to serve the rules, and it has ongoing workforce development partnerships along with UNR in the program, such as Be Here Nevada. And so I want to note that while we're reviewing the amendment, we look forward to continue to talk with the sponsor as this goes forward through the process, but we're happy to be support here today.
Thank you. Good morning, Chair Pazina and members of the committee. My name is Victoria Erickson, E-R-I-C-K-S-O-N, and today I'm here to testify in strong support of Senate Bill 425 on behalf of the Nevada Board of Examiners for Social Workers. I do have a written statement because I'm also a licensed social worker. I'm also an adjunct professor at the University of Nevada, Reno. So I could very easily go off script, so I have it written, so I don't do that. I'm very excited about this bill. I do want to thank Senators Danyate and Titus and the Dean of Social Work at the University of Nevada, Reno, Dr. Wyszynski, and Dr. Weiss for meeting with me about this bill. We had a very good, open, and informative discussion, and we believe this bill with the proposed conceptual amendments will enhance the practicum and training site opportunities for students of social work. These changes are not only technical corrections, they are essential to maintaining the integrity of Nevada's social work education programs, ensuring that our students are governed under the appropriate regulatory structures. For these reasons, I urge this committee to support Senate Bill 429 with the proposed amendments. Doing so will uphold the educational standards of the profession while allowing the board to remain focused on its licensing and disciplinary functions. Thank you again for this opportunity to testify.
And thank you so much for the work you do in the state and social work.
Good morning, Chair Pizzino, members of the committee. For the record, my name is Jimmy Lau, and my second iteration this morning representing Dignity Health St. Rose Dominican and our 7 acute care hospitals down in Las Vegas. As a mission-driven system, social workers play a very important role in providing care to patients. Just to give you a couple examples of some of the things that they work with us on, if an individual comes in and they're a victim of domestic violence or abuse, social workers are the folks that help them navigate resources to get out of those situations. If a person comes in with substance use disorders, social workers are the ones that help them navigate towards resources to help them improve their lives and get off of the substances that they're addicted to. Very critical in all aspects of the healthcare that we deliver, from the folks that come into the emergency rooms to the folks that are having surgeries and those that are staying in the hospital for other reasons or being discharged. So happily in support of this bill. Thank the committee for hearing it and urge your support. Thank you.
Madam Chair, members of the committee, Michael Flores on behalf of the University of Nevada, Reno. Happy UNLV Day and happy to be here on this bill, and really want to thank Senator Titus and Senator Donate for their leadership on this. They got us all together early in session to talk about the need and shortages around social workers in this state, and really glad everybody was able to come together. We're in strong support, obviously, of SB 429, and we work really closely with UNLV and their social work program, and we will continue to do so. And we compete in a lot of things, but if we can meet the need in this state on social workers, we'll work all day with UNLV and look forward to those opportunities and everybody in the state. Thank you.
Thank you so much, and happy UNLV Day. My husband is a proud alum. All right, I don't see anyone coming to the tables in support in Las Vegas, so we are going to move to the phones broadcast. Is there anyone who would like to testify in support of Senate Bill 429?
If you would like to testify in support of Senate Bill 429, please press star 9 now to take your place in the queue.
Good morning, Chair and members of the hardworking committee. This is Dora Martinez, and I'd like to thank Dr. Senator Titus and Dr. Weiss and all who are sponsoring this bill. We encourage you to please pass it, and thank you so much, and go Pack.
Chair, you have no more callers in support at this time.
Thank you so much. And not only has she called in support, she's laid down the gauntlet, but I see our UNR and UNLV representatives sitting in harmony next to each other right now. All right. Well, that will move us out of support on Senate Bill 429, and we will move to anyone who'd like to testify in opposition is welcome to the table. And I don't see anyone in Carson City, but I see someone who's coming to the table in opposition to Senate Bill 429 in Las Vegas. And you may begin when you're ready.
Thank you. Good morning, Chairwoman Pizzina and members of the committee. My name is Angelina Tingy, ANGELINA-TUENGE, and I'm a Master of Social Work student at UNLV with a concentration in management and community practice. I'm here today as a constituent urging your opposition for SB 429 due to potential harmful consequences for MSW and BSW students. As a social work student, we are often taught that there are 101 jobs in social work. The law should not limit us to one area. I'm personally interested in bringing social work values to policy and advocacy roles that are not typically filled by a social worker. I already struggled to find a practicum site that fit my interests with only 2 options not requiring a mental health or case management position. SB 429 would take decision-making away from the field office staff and put it into the hands of the Board of Examiners for Social Workers. The board would have the power to decide which agencies can be practicum sites with a clearly stated focus on medical facilities, government entities, and schools as outlined in Section 4. While these are agencies that benefit from social workers, they are not the only areas where social work values and ethics are crucial. I fear practicum sites will be excluded from social work education under this bill, especially nonprofit organizations, because they are not specifically mentioned. I strongly believe social work students should be compensated for their time and work. However, this bill does not clearly outline if students' compensation will align with cost of living or the minimum wage. I'm concerned that incentivizing practicum sites for students to become licensed social workers will pressure students into a costly decision rather than focusing these funds on the students.
Additionally, the amendment to Section 17 further limits students by only providing scholarships for some practicum sites, again, not mentioning nonprofit organizations specifically. With the amendment, 20% of the $2 million for the 200 students equates to about $2,000 per student at UNLV. Personally, that's not enough to pay my bills. This bill harms social work students by limiting our education, our future careers. That is why I would love to work with the committee to improve it. However, as currently drafted, I urge your opposition to SB 429. Thank you for your time.
Good morning, committee members. My name's Marty Clausen, M-A-R-D-E, excuse me, Clausen, C-L-O-S-S-O-N. I am employed at UNLV as the Director of Field Education in the School of Social Work, but I'm here testifying on a personal note. It is important to note that although having paid practicum sites for students is very important, and I would love to see that opportunity for all students in all practicum sites. The current bill does not specify, does not give enough money to be able to do that. Limiting the practicums to a very small number of practicum sites limit learning opportunities for all students. The programs at UNLV and UNR are accredited by the Council on Social Work Education. Bill 29 does not address all the nuances associated with field education and the accreditation requirements. Students are required to take field experience classes as part of their curriculum. And as mentioned earlier, they are required to do a minimum of 900 hours for MSW students and 400 hours for BSW students by the Council on Social Work Education. Each school, UNLV and UNR, have our own specific requirements. The field practicum is designed to help students develop skills in theory, application, at the micro, meso, and macro levels, provide students with real-world experience of how social service agencies work with client systems and observe a social worker in practice, help students to investigate how concepts of social justice and multiculturalism are implemented in the field, assist students in identifying how generalist social work practice is based on the core mission of the profession, help students identify strengths and resources for client systems, support students in integrating concepts about human behavior in the social environment into proficiency in working with individuals, families, groups, organizations, and communities, guide students in initiating and building upon client-worker relationships, help students understand the tasks of collecting and assessing information related to client concerns, aid students in recognizing client issues, problems, needs, resources, and assets, facilitate students' use of empirical knowledge and technological advances in working with client systems, and help students become familiar with program outcome evaluations, and informing practice effectiveness. As you can see, social work includes workforce outside of healthcare. There are over 100 different types of social work jobs. Bill 429 limits the type of social work practicum sites and would prevent students from having a variety of practicum sites, including those that are considered non-traditional social work sites to choose from, and limits the various types of social work practicum opportunities to a select few that the board decides is the most important to end this bill. It also limits students' creativity in designing their learning contracts.
Man, thank you so much. We usually have a 2-minute limit, and we've gone
needs.
about 3.5. So if you can just finish up, and then please turn in your comments to our committee secretary so we have everything in writing and the whole committee has access.
Okay, I would urge the committee to not pass this bill at this time, and I would love to participate in future discussions regarding this bill as we can look forward to identifying ways that we can fund practicum opportunities for all social work students. Thank you very much.
Thank you so much. And if we can get that turned in by email, just so we can make sure we have all those comments for the committee. I don't see anyone else in our physical location, so we're going to move to the phones. Broadcast, do we have anyone on the phone lines in opposition of SB 429?
If you would like to testify in opposition of Senate Bill 429, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you so much. We are going to move to neutral. If there's anyone in our physical locations who'd like to testify in neutral on SB 429, not seeing anyone coming to our tables, we are going to hand it back to you, Broadcast. Is there anyone on the phones who'd like to testify in neutral on SB 429?
If you would like to testify neutral on Senate Bill 429, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. Well, we will invite the presenters back to the table to make any closing comments on Senate Bill 429.
Senator Titus for the record, and I just want to acknowledge the committee, Senator Pazan and all of you folks on this committee. You folks hear a lot of bills. It's been a busy week, busy couple months, and your dedication does not go unnoticed, so I appreciate the opportunity and the time. I urge you to support SB 429, and yes, $2 million is probably not enough in many folks' eyes, but in a time when we are looking at solving some solutions, this is a true start. It may not be as much as we would like, but I think in this current economic era, we're going to have to be realistic. And I think the goal here of this is expanding the access to social workers across our state. I did include what I thought was all players during when we had these meetings, including UNLV students. We included staff, deans, universities, and all of those folks, but there's always, if we didn't reach anybody, they certainly can reach out with suggestions on how we can make this bill better, because in reality, it's about our whole state and trying for solutions. I also want to acknowledge your staff, the committee policy analysts who helped work on this, who put a lot of time when there's a lot of other things going on. So this is really a community effort, and I'm proud of the folks who've worked on this bill. Please support it. Thank you.
Thank you. Sit tight for one moment. First, I would like to also commend the committee staff who has been working around the clock, especially in this deadline week. We are so incredibly grateful for all of them. So thank you very much. And thank you for making notice of that. And then I believe Senator Scheibel had a question.
Yes, and I know that we have a lot to get through, but I thought it was important to acknowledge some of the opposition. The way that I'm reading this bill, I understand we're only funding $2 million. That won't cover all of the social work students. So we have to figure out a way to determine, being blunt, which students get the stipends and which students don't. And so you've provided a list of criteria: students that are in rural access hospitals, on tribal lands, in counties whose populations are less than $100,000. Those requirements only apply to getting the stipend from the $2 million. It doesn't change the overall eligibility of other practicum sites for students to participate in those practicums in order to get their licenses, correct?
Absolutely correct. Thank you, Senator Titus, here for the record, and thank you for the clarification, Senator Scheibel. That is absolutely correct. And again, because we have limited funding, we want to make sure, the reason we chose these particular practicums is it costs money to go out to those areas, and that it helps with some of that living expenses, that travel, the fuel to drive out to there, and so and then the priority, of course, in urban areas that are in need. And so we have to pick a line sometimes, but it doesn't limit their licensure. It doesn't change what students have to do. So thank you for the clarification.
Thank you so much. And with that, we thank you very much, and we will close the hearing on Senate Bill 429, and we will open the hearing on Senate Bill 438, providing for the licensure and regulation of merchant acquire limited purpose banks. And we will welcome the Secretary of State's team to the table. Thank you so much. Also to the committee, please note there is an amendment on this which changes the bill significantly. And I will say to Secretary of State Aguilar, I wish he had provided this amendment before I read this entire bill. Thank you.
Thank you, Madam Chair, members of the committee. Absolutely understand. My name is Gabriel Tequera. I serve as the Chief Deputy Secretary of State under Secretary of State Francisco V. Aguilar, and I'm here on his behalf today. Yes, absolutely, the amendment changes the bill significantly. However, I will say this bill is intended to be a companion bill to Speaker Yeager's bill, AB 500. Much of the text of the introduced draft of the bill is very similar to the text of AB 500. And so your work was not in vain, Senator Pezzina, because much of that language will be making its way to this committee after it's out of the Assembly. So this bill creates the ability for the Commission of Financial Institutions to charter a new type of bank, payment banks in the state of Nevada. A payment bank is a type of bank which would be able to provide specific services, such as payment processing, but does not engage in other banking activities like lending, for example. Now, I am not an expert in these matters and do not pretend to be, but helpfully we have a rather simple conceptual amendment which greatly narrows the scope of this bill. If legislation creating payment banks were passed, so AB 500, SB 438 as amended would allow a state agency to apply for one of these payment bank charters. And I'll use the Secretary of State's office as an example. So historically, before Secretary Aguilar took office, the Secretary of State's office covered the credit card charges for all customers that ran their credit cards through the Secretary of State system. That did a few things, although it was good for the customers. It cost the state millions of dollars a year and was also incredibly difficult to budget for, meaning that the Secretary of State's office had to continually ask for supplemental funds to cover those credit card fee charges. Now, we have shifted that policy. We have passed on that cost to the customer, as most other state agencies do. However, what that means is that $3+ million a year as the volume of our transactions increases, that goes to Wells Fargo. They process the payments for us, they accept those fees, and they receive that revenue. We have, what this would allow a state agency to do is create a charter for a payment bank so that the state agency could work directly with the credit card companies to handle those services. That would save the state and customers money because we could do that at we would not need to include a bank's profit margin in that payment processing fee. We have discussed this bill with the Financial Institution Division as well as the Treasurer's Office to talk about how this could work. Payment banks are a new type of entity, and I will be frank in saying I don't know all of the technical logistics that would be required to set up a state agency as a payment bank doing payment processing. But this legislation is enabling. This legislation, if passed, and again, only if AB 500 were passed, creating the ability for the FID to charter payment banks, this would allow state agencies to begin the kinds of conversations they need to have to eventually serve as a payment bank and payment processor for the state of Nevada. AB 500 has the ability to bring new business and a business-friendly environment to the state of Nevada. SB 438 would allow the state to save millions of dollars annually and simplify our financial transaction process. So with that being said, thank you very much, Chair Pezzina and members of the committee, and I'm available for questions you may have. I will do my best to answer them.
Thank you so much. Do we have any questions from the committee? Okay, we'll start with Senator Flores.
Thank you for the presentation. And I think, like the chair, there was a lot of research and a lot of reading that was done to try to understand what was happening here. For sure would have wished we would have seen this amendment a long time ago. But all good. Two things. I'm just curious, with what you're doing here and just keeping Section 40, all that section says is you may do this. And I'm curious to know why we're doing this companion bill, because the entire bill, as originally written, was ensuring that we weren't allowing the merchant bank to have extended, broader powers, right? Like a traditional bank we would be accustomed to seeing. But now we're saying merchant bank may, and they may implement rules, period. Aren't we now going right back to the original concerns that the entire bill was trying to address? Because we're not putting any parameters in this bill. What happens if the other bill dies and this one passes, and we have none of those restrictions in place, none of those requirements in place? I'm just trying to understand what the mindset is, and not just keep it all in one bill to ensure that we're doing exactly as intended.
Thank you for the question, Senator Flores. Gabriel DeCara for the record. So absolutely, the Secretary's intent with this amendment is that without the other bill passing, without the having those clear requirements set for the Financial Institutions Division, without all of those kinds of checks and balances to ensure that the payments bank is only operating in the limited authority that the state of Nevada can set, that this bill would not, as amended, would not create the ability for a bank like that to exist. That if this bill is passed and that bill dies, then assuming at some point in the future that the ability for a payments bank is created, the state would be able to obtain a charter. The goal is not to set up some kind of parallel or secondary process. As to why these are two separate bills, I know that the Secretary, as well as Speaker Yeager, had conversations with a number of stakeholders about the goals here, both bringing business to Nevada and allowing the state to save millions of dollars a year. What we ended up with two very similar bills. The Secretary of State feels very passionate about the element of the bill that is, again, related to saving the state money and simplifying the financial process for state agencies that do payment processing. We are supportive of the other bill and still in conversation of the state with those stakeholders. This was just the way things broke down. Thank you.
Madam Chair, may I switch topics? Please.
I'm going to hand it back to Senator Flores in a moment, but I think the question a few of us on the committee have had, including our legal counsel, is why not just amend this section into AB 500?
Gabriel DeCara for the record. Thank you for the question. I think the answer to that is that there were different timelines in play. We did not have the ability to determine exactly what AB 500 was going to look like. There was further negotiation that was happening with the Speaker, and we had to turn in our BDR. So this legislation is based on similar legislation out of the state of Georgia that created payment banks. But again, the important part for the Secretary is the ability for the state to have its own charter to be able to conduct these kinds of transactions themselves. We're very open to amending this into AB 500, but we wanted to be sure that the portion of the bill that allows the state to save that money was covered, and we had to get something into LCB. Thank you.
Okay, thank you so much. And we can have more discussions on that, but I think we might have more questions. Senator Flores, and thank you.
And thank you for that, Madam Chair. The other thing I just wanted to understand more broadly, and I understand that there's one more other state that's a kind of a player in this space, and I appreciate innovation and us doing something new in Nevada, right, and being in the front end of it. I'm just curious to know now, so for example, in my business, I have different apps, right, and traditionally I do everything through Chase. The client comes in, they make a payment, Chase will charge a percentage for that transaction. But then I also have other apps that I use, and most of them is just for client management. And in those apps, they allow for my clients to make payments through their app. And my understanding is and as an incentive for me to utilize that program, they usually waive those merchant fees. And I was curious to know, does that mean that app that I'm using is probably just swallowing the merchant fee on their side of it that the bank would traditionally charge Chase or Wells Fargo in the kind of scenario that you painted? Or are they kind of operating as a merchant bank? So I'm just curious to know
Gabriel DeCara for the record. Thank you for the question. So my understanding is yes, they are eating that fee. So presently, even though Georgia passed this legislation, I do not believe any of these charters have been created, or at the very least, contracts have not been set up. So there are the credit card companies, and then there are the banks. And presently, those intermediaries, so let's say Stripe, for example, Stripe's used to run a number of credit card transactions. Stripe can't contract directly with Visa or MasterCard. Stripe has to go through a bank, which charges a cut, and the bank has the contract with Visa or MasterCard. What this would allow is for an entity like Stripe that does the payment processing, or in the case of SB 438, the state of Nevada, to contract with the credit card company directly, so that there's no middleman and no additional fee charged on the processing of those transactions. I hope that answers the question.
It does. Thank you. Thank you, Madam Chair.
Okay. Do we have any other questions from the committee? All right. Thank you so much. Let's talk further about this later, just in regards to AB 500. But we thank you so much for the presentation. We really appreciate you being here today and educating us on this. And now maybe I don't feel quite as bad about reading the entirety of that bill. Okay, with that, we welcome anyone who'd like to come up in support of Senate Bill 438 to approach our tables in our physical locations. And not seeing anyone coming up, we are going to move to the phone lines. Broadcast, is there anyone on the phone lines who'd like to support Senate Bill 438?
If you would like to testify in support of Senate Bill 438, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Thank you so much. With that, we will move to any testimony in our physical locations in opposition of Senate Bill 438, and then after that, we will move to the phone lines.
Chair Pazina, members of the committee, Connor Kane, CONNORCAIN, on behalf of the Nevada Bankers Association in opposition to Senate Bill 438. I'd like to begin and conclude with the same message, which is that we've had encouraging dialogue with Secretary of State Aguilar, who has been transparent throughout this process, and are hopeful that we'll ultimately find a pathway to address our concerns. However, at this time, we are opposed to this bill. The retail payment system, how payments move between customers and vendors or person to person, is a long-standing trusted system that works efficiently and safely for customers, businesses, and communities. From a regulatory standpoint, any new entrants into Nevada's financial system, especially those handling customer money and sensitive data, must meet the same high standards as existing institutions. That means robust licensing, regulation, supervision, and insurance. Customer safety and data protection must remain top priorities. We support promoting diverse charter opportunities for our state. However, our concern with SB 438 as written is, and frankly, we're digesting the conceptual amendment and how the Secretary of State's office or someone else creating a new charter would potentially impact FID. But given how the Financial Institutions Division is currently funded, a significant portion of the cost to set up and regulate the new payment charter would be incurred by our 11 state chartered banks, considerably increasing their assessments. With that being said, again, we've had encouraging dialogue with the Secretary of State, and we're hopeful that we'll be able to find a fair and equitable solution in this bill. We thank you for your time and look forward to the opportunity to continue discussions. Thank you.
We have a quick question for you from Senator Flores.
Thank you. If something like this moves in Nevada, do you see some of the folk that you represent trying to create kind of a sister entity, brother entity that maybe starts getting into this space, or do you see them trying to navigate into it? I'm just curious to know how you see that relationship moving forward.
Chair Pazina, through you to Senator Flores.
And you can go direct. Thank you.
Thank you very much. I think it's possible. I think, frankly, as we're looking at new charter opportunities, we welcome diverse charters, right? We want folks to come into the state. We currently have a couple of industrial lending charters that are part of our state chartered banking institution infrastructure. We would welcome diverse charter opportunities here. We would try to partner with those entities. I think from our perspective, from a regulatory standpoint, from a licensing standpoint, from an insurance standpoint, we need to make sure that we've got the right safety measures in place, the right guardrails to protect consumers, to protect the state. Those standards are really high, for our state chartered banks, and we want to make sure that they're as high for any new bank coming into the state, regardless of what type of charter it has. And then in addition to that, Senator, we want to make sure the playing field is level. So given, again, I talked a little about the Financial Institutions Division and how it's funded, the depositories, right, the state charter depositories, which are banks and credit unions, end up based upon their asset size, essentially paying any additional fees to help fund the Financial Institutions Division. So when you set up a new charter, there's a really high cost. I think for a charter like this, and I understand there's an amendment, but it would be north of $5 million. So those state chartered entities that are depositories would end up picking up that cost. So not the other entities that are regulated by the Financial Institutions Division are typically charge an hourly rate for their supervision. Whenever there's an excess cost for the division, the depositories end up having to fill that gap. And so that's our biggest concern, is making sure we're on a level playing field. But to be more direct in answering your question, we welcome competition, we welcome diverse charters, we welcome other folks to come in and work with us. We just want to make sure the playing field's level.
Okay, thank you so much. And not seeing anyone else in our physical locations, we are going to move to the phone lines. Broadcast, is there anyone who'd like to testify in opposition of Senate Bill 438?
If you would like to testify in opposition of Senate Bill 438, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you very much, and that will move us to neutral on Senate Bill 438. Anyone who'd like to come up in our physical locations to testify in neutral? Not seeing anyone, we are back to you, Broadcast. Thank you so much for all of your help. And is there anyone who'd like to testify in neutral on SB 438?
If you would like to testify neutral on Senate Bill 438, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. Would you like to come up and make any? Okay. And I think we were planning to connect later today anyway, so let's connect on this as well. Thank you so much. And with that, we will close the hearing on Senate Bill 438. And we thank you so much for the presentation. And we also thank our presenters on SB 440 so much for their patience in a very long wait this morning. But we are now looking forward to hearing the presentation on Senate Bill 440, revising provisions relating to electricity. And with that, we will welcome our presenters to the table.
Thank you. Good morning, Madam Chair, members of the committee. Edith Duarte for the record, DUARTE with Western Public Affairs, today representing the Nevada Solar Association. Thank you so much for hearing this bill. We really appreciate you taking the time to go over this bill with us. I want to just really quickly mention that there is an amendment that was submitted yesterday, and it does strike sections 1 through 12 of the bill. That bill has to do with lending, solar lending. That bill primarily went into 379. We're working with Senator Fabian Doñate on that and with FID. And so what is left in this bill really is the utility, HOA transparency, homeowner and contractor accountability. So that's what we're going to be going over today. I do want to mention that we have Dallas Harris that is available via Zoom to answer technical questions. She is a long-term attorney for the Nevada Solar Association. And I have Steve Hamili next to me who will go through the bill very quickly. And then the last thing before I hand it over, is there is one amendment that was submitted by Garrett Gordon. I think it should have been provided to you. It is a friendly amendment. It is a Section 13 amendment, which is the HOA component of this bill. It was a drafting error on our part, so we do accept that amendment as well.
Morning, Madam Chair and committee members. Stephen Hamili, the Hamile, with the Nevada Solar Association. Nevada has made a name for itself as a national leader in clean energy policy. With one of the most ambitious renewable energy goals in the country, we've seen tremendous growth in solar adoption, and along with it, tremendous job creation. Thousands of Nevadans are now employed in solar installation, sales, engineering, and manufacturing. These are well-paying, future-forward jobs that support families and build communities. But with growth comes responsibility. Every week at the Nevada Association, we hear of homeowners who have been misled or outright taken advantage of during the solar sales process. And while the stories may vary, the damage is real, both to individuals and to our industry. Sometimes an out-of-state company pretending to be local, sometimes a sales rep dresses like a utility worker in a yellow vest to build false credibility, and too often consumers are misled with promises like, the state will pay you for the system, or you can walk away at any time. One of the most heartbreaking stories came from a 75-year-old working gentleman named Albert. His wife was in hospice when a solar salesman, unlicensed and working on commission, convinced him to sign a 25-year contract, power purchase agreement. Albert was told that he could cancel this agreement at any time through incapacitation or death. That wasn't true, and now he fears that he's left with a financial burden for his heirs. This is not the Nevada way. These bad actors don't just harm consumers, they hurt every honest solar company working hard to do the right thing, and they jeopardize our state's clean energy progress by turning people off from solar altogether. That's where Senate Bill 440 comes in. This bill builds on the progress of 293 and other consumer protection measures by creating clear standards of accountability and transparency across the entire solar transaction, from the installer to the utility. First, the installer. Under 440, it ensures that the installers clearly disclose whether they are truly local. A local company is defined as having a physical presence, a physical office, and a registered vehicle in the state of Nevada, along with proper licensure. This helps consumers make informed decisions and encourages economic investment in our state. Installers must also provide the make, model, and numbers of the equipment, not just generic descriptions of the equipment, so that consumers know exactly what's being installed. This cuts down on bait and switch tactics that some companies have used to swap promised products for cheaper alternatives. And finally, all sales presentations must be done by a direct employee of the installer, not an unlicensed commission-based third party. The installer must certify that all sales practices and installations comply with local, state, and federal laws. On the HOA, current state law prohibits HOAs from, quote, unreasonably restricting the installation of solar, but it does not define what unreasonable is. The vagueness often results in conflicts or inaction, leading to fewer systems being installed. SB 440 changes that. It requires HOAs to adopt clear, written solar guidelines. If a homeowner follows these guidelines, the HOA must allow the installation, balancing aesthetic standards with clean energy progress. The cooperation helps eliminate rogue installations while empowering communities to go solar in a thoughtful and uniform way. The homeowner, they're also responsible. 440 assigns responsibility to the homeowner, asking them to disclose any and all modifications made to their property that could affect the installation, such as prior electrical work or unpermitted structures. The homeowners must also commit to providing timely documentation and support to complete the project, ensuring safety, code compliance, and smoother operations. And the utility. Finally, the utility plays a vital role in completing the solar installation. 440 asks utilities to make their best efforts to expedite the interconnection process. This includes permission to operate, temporary disconnections and reconnections, and this provision is about efficiency, getting homeowners the benefits of solar faster without unnecessary delay. Think of 440 as the blueprint for responsible solar adoption. It's not about creating more bureaucracy. It's about streamlining the process, protecting consumers, and supporting the business of doing the right thing. Nevada should be leading the nation in solar adoption, not just in solar installations per capita, but in consumer trust and integrity. This bill helps us get there. To be clear, most solar companies in the state of Nevada are doing the right thing and operating ethically. They're locally owned, deeply invested in the communities, and committed to serving Nevadans while save money while helping our state meet its climate and energy goals. SB 440 protects their reputation and helps lift the entire industry. Thank you very much for allowing me the time to present, and look forward to hoping for your support. Thank you. Here to answer any questions you may have.
Thank you so much. Do we have any questions on Senate Bill 440? I know we all heard Senate Bill 379 not long ago, and the first number of sections were very similar, so they've been deleted, but this does cover more HOA territory. So any questions? Senator Ellison.
Thank you, Madam Chair. I'm glad to see some of the amendments that are in here, but I tell you that I have to deal with these guys a lot in rural Nevada, and I hate to say it, but they're not ethical and they're not honest. And I've seen seniors lose so much of their houses by damage because of these guys coming in out of Idaho or Utah. They're not licensed, and the problem is they don't go get a permit. And this addresses getting the permit, go to the city or go to the county, and plus they got to have a C2 or better license. So it brings us into play with what the contractor board is doing. So I thank you for it. And I was kind of shocked there was this many things deleted, but I think they needed it. So, but thank you. That was a comment. You can repeat it on it if you want to, but we talked about this. There's some bad apples that come in overnight and do a lot of damage to a lot of people. So thank you.
I believe we also had maybe a clarification by Senator Daley he wanted to make.
Thank you. Just a question on clarification when I'm looking at the amendment. For instance, in section 17, what your amendment says is delete the changes in paragraph 1 and then 2A through M. So I wasn't sure. I see there's language in paragraph 1, so you're going to take out that language. It will remain existing. And then when you go to sub 2, I don't see any changes in the original bill in 2 through M. So you're not deleting that language. All of that language is still going to stay. And then you're just adding the N, 1, 2, and 3. It just wasn't clear in the amendment. You're not deleting existing language. You're just deleting any changes. And then for the parts that aren't mentioned, if there's other changes, those stay.
Stephen Hamili for the record. Thank you for the question. Yes, sir, that is correct.
Okay. It just wasn't clear in the amendment. When I'm looking at it, I'm going, are they proposing to delete all of those other pieces of language? But thanks for that clarification. That was my only question.
Okay. Any other questions on Senate Bill 440? Senator Flores?
Thank you, Madam Chair. And sorry, I'm just now kind of getting into the amendment. And so you may say it's not even there or germane to it now, but I was just walking back through the memory bank, and particularly my Senate district, when it came to issues with folk who were working with some of these businesses to get solar installed. And I know some of the hypotheticals that they brought up were business A did the job, disappeared on them, but later that contract was bought out by business B, a much larger company, and they kind of assumed the responsibility on that. I see here that you do have like a record-keeping requirement, I think for the 4 years, I think is what you have there. Do you know in that hypothetical, number one, you may push back on that and say that's not really happening, so I was just curious if that's a thing. And then number two, the record-keeping requirements would also include them having to kind of backtrack whatever was done by the previous company once kind of umbrella company B took over. But have you been seeing that? Because that's some stuff that was brought up to me, but I don't know if that's something you've seen yourself. And I just want to know what the record keeping will look like for those.
Stephen Hamili for the record. Yes, Senator Flores. That was covered under Senate Bill 293 with regards to maintaining a recording for 4 years. And what our bill does is it requires that bill be that recording be supplied. It wasn't defined in 293 that in the event that recording were requested by a lender, a homeowner, or any other agency that would have to be supplied. That's the purpose here. With regards to the industry practice of a company taking over another existing entity or their contract, there is no provision currently now for successor liability or any transfer of information. Generally, when a contractor assumes a contract from another, that's because that original contractor is likely out of business. And we're coming in, or one of us is coming in to perform either getting the system up and running or making some type of remediation or repair.
Understood. I appreciate that. Thank you.
Okay, any other questions on Senate Bill 440? And this was also added to the agenda late, and I know it's been challenging with so many bills in deadline week to hear, so I appreciate all the committee's hard work on these. Okay, we'll have you step back from the table, and we will welcome testimony in support of Senate Bill 440. We'll start in our physical locations and then move to the phones.
Good morning, Chair. Good morning, Committee. For the record, Garrett Gordon. I'm a partner at the law firm of Womble Bond Dickinson, today representing the Community Association Institute, who advocates for approximately 3,000 homeowners associations in Nevada. First, I want to thank Edith and the Solar Association for working with us. They're correct that language in the statute currently says a homeowners association cannot unreasonably restrict solar installations. We worked on that language sessions ago, and we agree it needs some clarity. It has some ambiguity, so appreciate this bill and the new statutory scheme for approving these units in associations. I did submit, as Edith mentioned, an amendment. It's a friendly amendment. It deals with section 13, and it strikes out the last sentence. The purpose, Chairwoman, for the amendment is it does reflect the fact that if an association does not approve a system within 15 days, it would be deemed approved. The issue with that is architecture review committees normally meet monthly, not biweekly. So the 15 days just doesn't work for the associations, and I appreciate that's a friendly amendment and that language would be struck. Happy to answer any questions, and thank you, committee, for the time.
Good morning, Chair and members of the committee. For the record, my name is Christy Cabrera Georgeson. I'm the Deputy Director of the Nevada Conservation League, and we're here in support of SB 440. Rooftop solar is one of Nevada's best tools to lower bills, reduce pollution, and tap into Nevada's most abundant natural resource, our sunshine. As the #1 state for solar potential, more and more Nevadans are going solar every day. This bill will help ensure homeowners and HOAs aren't blocked out from reaping the financial and environmental benefits of solar power and takes important steps to protecting solar customers. We urge the committee's support. Thank you.
Good morning, Chair Pazina, members of the committee. For the record, my name is Jimmy Lau with Ferrari Reader Public Affairs. For my third and final iteration in front of this committee this morning, representing Sunrun, we'd like to thank the proponents and the association for working with us on this bill, and we are in support. Thank you.
Okay, thank you so much. I don't see anyone in Las Vegas, so we are going to move to the phone lines in support of Senate Bill 440.
If you would like to testify in support of Senate Bill 440, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Thank you so much. With that, we will move to testimony in opposition of Senate Bill 440. If anyone would like to come up in opposition, and I don't see anyone in our physical location, so we are going to move to the phone lines broadcast.
If you would like to testify in opposition of Senate Bill 440, please press star 9 now. Chair, you have no callers in opposition at this time.
Thank you so much, and that will move us to neutral. Anyone who'd like to testify in our physical locations? I don't see anyone coming up in neutral on Senate Bill 440, so we will go back to you broadcast on the phones for anyone who'd like to testify in neutral on SB 440.
If you would like to testify neutral on Senate Bill 440, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. With that, we'll ask you to come back up and make any closing comments if you have. Okay. All right. Well, thank you so much. We will close the hearing on Senate Bill 440 and move to our last item on the agenda today, which is public comment. We welcome anyone who'd like to make public comment in our physical locations as well as over the phone. The call-in information is located on the agenda. We look forward to hearing your comments. We ask that you keep them brief and please avoid repetition of comments made by previous speakers. Finally, we ask that you clearly state and spell your name for the record, and we'll begin in our physical locations for anyone who'd like to make any public comment germane to commerce and labor. Not seeing anyone coming forward, we will move to the phone lines broadcast. I believe we do have someone who'd like to make public comment. I hope that they stayed on the line. We welcome their public comment, and we will open it up to the phones.
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Hi, can you hear me?
Yes, thank you so much, and please proceed.
Hi, good morning. Sorry, again, it's my first time calling in as well, so it's kind of following the process here. My name is Austin Richardson for the record. It's Austin and then Richardson, Richardson. I am a member of LVDSA. We had a BDR that was submitted by the Interim Committee on Commerce and Labor. This BDR was for a bill that would have been capped for rent increases at 3% per year. We spent the last few months collecting signatures and support for the bill, which I personally was out doing. There's, overwhelming support from a lot of the constituents. However, the bill was not introduced. We know it exists. So our question to you, which we know you can't answer here, is where is the bill? When Nevada is facing some of the steepest and fastest growing rent prices in the country, why have you abandoned your responsibility to us? Thank you.
Thank you so much for your public comment, and I can tell you I did not see that bill and did not serve on the interim committee. But I look forward to working with you at a later date and having these discussions. And I thank you so much. And if you look at the legislative website, you can find my contact information there, and I look forward to continued discussions. With that, broadcast, do we have anyone else who's on the phone lines?
Chair, you have no more callers at this time.
Thank you so much. And also, I'd like to thank everyone who calls in, whether it's in support, opposition, neutral testimony, whether they're calling in on public comment. We really, really appreciate everyone getting engaged in the legislative process. It's so important. And with that, we will look forward as a reminder to seeing you for an intense work session tomorrow at 8:30 a.m. in committee. So we realize that's not one of our traditional days, but we will be back here tomorrow at 8:30 a.m. And we thank you all so much. And with that, this meeting is adjourned.